All right, welcome back to Protecting the Legal Rights of Artists and Designers. We're picking back up with contract law, and we left off with the basic elements of contract. We're going to talk about the statute of frauds now, or in plain English, written versus spoken word. Should a contract be in writing? I get asked that question a lot. The answer is, oh my God, yes. If you want to enforce the terms of what you agreed to, then yes, it is proof of what you were thinking at that moment in time. It's the evidence when somebody says, that isn't the deal that we made. Get it in writing, get it in writing, get it in writing. Get it in writing because it's your chance to literally spell it out, to make it clear what you want and what you expect you will do and what they will do. What you say isn't always what gets heard. People get distracted. They have different perceptions and vocabularies and experiences as a base. People can be desensitized to what you mean and so don't understand the value of what you want or the value that you bring. And people can be focused on their agendas and not focused on yours. What you want, what you need, and what you expect. Get the terms of the contract preserved on paper at the beginning when it's all smiles and handshakes. People's memory changes and fades. Time passes, they forget what they agreed to. It acts as a reminder. And sometimes there are bad actors. Intentional misconduct. People will say and do things to get you to do what they want without any intention of following through. If you have to enforce a contract, having it in writing will help you prove your case and what they were supposed to do. Does it have to be in writing? There's a legal standard called the statute of frauds. For certain types of transactions, the terms have to be in writing to enforce them. The nature of the relationship is so important that it needs to be memorialized. So, for the purchase and sale of land, real estate, for transactions with a value over $500, for a contract that will be for a year or more, and for when someone is taking on the debt of someone else. Those are all times when the statute of frauds applies. You have to put that transaction in writing in order to enforce it. Does it have to be in writing? Yes, under the statute of frauds. If it's for over $500 worth of value, if it's for land, yeah, that's land, that's a mountain. If it's personally assuming the bills or debt of someone else, or if it's for a year or longer in length of time, you have to put it in writing if it's going to be enforceable. You want to enforce the contract. Other than these, no, it doesn't have to be. When it's not in writing, it's a spoken contract, or what attorneys call an oral contract. Oral contracts do not have to be in writing, and they are still enforceable even if they weren't. But it's harder to prove, harder to enforce if you need to. So don't let the contract be all talk. Get it in writing. That leads to what constitutes a writing. So what is sufficient? What is a writing? First of all, don't just have a contract for the sake of having a contract. Most people have the urge to go on the internet and Google for a contract, any contract, and say, okay, good enough. I've got a contract, done. Don't do it for the sake of just having something on paper. A bad contract can be worse than no contract at all. You can be obligated to do things that you never intended to do if you just do a copy and paste. It should be specific to the relationship and the details should match. The format can be paper or electronic, it can be old-fashioned or digital, and it should contain the essentials for a contract. Remember, parties, time, place, and quantity. At least get the basics. Get it in writing is my mantra. Get it in writing, get it in writing, get it in writing. Make sure that it's tailored to what you expect. Don't just do it for the sake of having it. Make it work for you. That brings us to the last piece for this video. Read the contract. Whether you're handed somebody else's contract or if you're using your own contract, read the contract. Don't get what we call buyer's remorse. You're handed the contract and just sign it or click on a button that says, I accept or okay. Even if it's someone you trust, there could be unintentional mistakes. Make sure that the details match what you negotiated, match what you discussed, match what you talked about. Once you sign the contract, you could be stuck. There's this legal rule. It's called the parole evidence rule. You can't use previous outside evidence of parties' intent once the contract is in writing. You go to court because you're not happy with the contract that you signed. You didn't read it, and you didn't realize that there were details that you left out that were important to you. And now it's 2 months later, and you've done the work, you've performed, but you think they haven't. You're presenting the case, you have all these emails, recordings from conversations, video chats from Zoom meetings, all this great evidence, but you can't use it. The signed contract's what counts. All those other pieces of information, that proof, is not admissible. Once you sign it, that's what counts. Unless, well, look, if you have some specific reference that's going to incorporate that information, some specific reference to additional information, like an attachment that is written into the contract, it's called an incorporation clause, those pieces of information can be included in the contract. In fact, they're considered part of the contract. It is also possible later to modify the contract. You can modify it later if everybody agrees to it, and then you put it in writing, and you add it to the contract, or you replace the contract with a new contract. That's if everybody lets you. But why go through that? You're going to wind up having buyer's remorse if you don't read the contract, if you don't check the details, and make sure that it matches your expectations. All right. That covers the basics of the statute of frauds. Getting a contract in writing, checking the details, making sure that it works for you. We'll pick back up with defenses and excuses for performance in the next video.